what I find is I don't like the adamancy of the attorneys. I don't like attorneys that...
Oozy.
Oozy.
Look, when I'm in the hallway, I'm much nicer.
Welcome to episode 3 of our continuing 3-part series with Uzzell Branson. And we are thrilled to bring in a new member to this podcast, Judy Copeland. And I am going to let Judy tell us all about herself and her journey as to what she's doing today. Judy?
Well, I started law practice in San Diego in 1974.
Holy shit, they had lawyers back then?
Yeah, and you could park on the streets, and it was all very exciting.
And you could find street parking.
Yes, you could find street parking, and I don't think they charged for it at that point. And I worked for the county for 5 years, did some probate, and then they transferred me to litigation, but I really preferred probate. So I quit, set up my own probate firm, and I've been practicing privately ever since for about 40 to 45 years. And then I retired, and now I mediate probate cases. Probate meaning trust disputes, probate estates, conservatorships, estate planning, elder law. And so I mediate those cases now. Attorneys bring their disputes to me, including Uzi. And
Uzi.
Yes, that is.
See, we didn't get that in episode 1 or 2, but I appreciate that.
And they bring their disputes to me with their clients, and I try to get them solved because it's...
And the name of the firm that you work with now?
West Coast Resolution Group. And
when I just love I love the mediation space. I think it's fascinating. So tell me, what does that mean? I mean, there's arbitration, mediation, and I don't think a lot of the viewing audience understands the difference.
Well, arbitration is where you present a dispute to a private, usually an attorney or a retired judge, and they make a binding decision. They just decide, this is the way your case is going to be ruled on. I'm ruling on your case. Mediation, the parties keep control. I'm more of a facilitator, which means I don't have to do as much.
What, you don't like reading the 40-page briefs we send you?
Oh, I read the briefs. I definitely read the briefs and hundreds of pages of medical records, and they don't mark where I should be looking. Okay. And so I have one party in one room and another party in another room, however many parties they are, they're all in separate rooms. And I go from room to room, talking to them about why they should settle their case. And usually it's family members, and that makes it more difficult because there's a lot of feelings involved. When I give talks about mediation, I usually entitle them, Mom Always Liked You Best, because older people will remember the Smothers Brothers and the old sibling rivalries that develop over time. So
do you look at it differently now that you've been in the mediation space for several years versus when you were doing litigation and writing trusts?
Do I look at what?
Do you look at the arguments or differently, or when you did litigation?
Probate litigation, yes.
So you look at it, read differently now?
Very different. What I find is I don't like the adamancy of the attorneys. I don't like attorneys that...
Oozy.
Oozy.
Look, when I'm in the hallway, I'm much nicer.
The attorneys get their clients riled up, and it tells their client, I'm on your side, I believe you, but it also makes it harder to settle the case because it gets the client higher expectations. And not settling the case has such serious ramifications that I would just prefer everybody stay calm and let's just talk this out. But warring siblings, they're not going to stay calm.
I see him smirking over here. Would you like to start commenting on the conversation?
Well, it's true. And one thing I learned, and actually my first mediation I ever did was with you before you joined West Coast. So
yes.
When you were doing them, you still had your private practice. It was Jamie Kleinschmidt was on the other side.
Oh, sure.
And we had this brother and sister combo. And
no names, of course.
But they were, I remember, because in mediation, sometimes you start with a joint session. That's not as popular anymore.
No, it isn't.
It used to be, kind of start together and then you break up and then come back together.
The one I just went through one.
Oh, yeah?
And it was everybody in the same room.
That has its place.
I like it.
Well, I know you like it. I will remember this because there are two very colorful moments from this mediation. I'm going to call my client Bill, which is, of course, not his name. Bill and his sister they were very dramatic people. And I had spent a lot of time preparing Bill. You tell the clients, never, ever say someone's a liar. Because what happens when it says, oh, well, they're just lying? You just turn off. It's not convincing. It's not persuasive. And you kind of make yourself look dirty. As Bill, you can't say that you're going to have to be reasonable here. We're going to solve this, but we're going to push. We're going to push to get you the best deal that we reasonably can. And, that involves being, there's some puffery. There's some, we're not backing down on this. Hey, if we go to glory, this could go our way. And at the start of this session, Bill and his sister are sitting opposite each other. And it was, I think she spoke first and Bill was calmly watching her, probably afraid that I was going to punch him in the back of the head if he didn't. And then when it was Bill's turn to talk, his sister wouldn't look at him. She would look up and away because she was just so infuriated that, how dare he was the trustee.
Yeah.
And he'd done some work on the house and this and that. And it's just,
what was her beef?
I'm pretty sure she blamed him for everything from
being
global
born,
warming.
global warming, the weather, stock market. Her concern was that he had done things informally instead of hiring a master contractor to do. He called in a work crew here, a work crew there, and so. No, I don't want to approve these. I want you to pay for this improvement. Well, no, this is we're both benefiting from this when we sell the house. And of course, she hadn't been there. He'd been the one who took care of mom, who'd been smoking in the house for 40 years. Okay. And there's all the usual dynamics there.
I would like to point out, this is one of my...
you can please interrupt.
This is one of my pet peeves, is having family members, especially siblings, as trustees.
They weren't co-trustees.
No, fortunately
having a family member as the trustee brings up all the old rivalries, and they fight it. Now, it's good for my business.
Good for my business. Pays my mortgage.
But it's not really good for them.
No,
thank you. Nugget moment.
Yes. Yeah. To parody the old family law joke, the reason why professional and corporate fiduciaries are so expensive is because they're worth it. You get what you pay for. Yeah. And there are families. In fact, most families can get through it without legal intervention. Most. But
I don't see them.
Those ones we don't see.
We're all a little jaded in our world for what we've done. Maybe a little jaded because I just don't believe I would never name my child as my successor trustee.
I would say that about 90% of administrations are administered improperly and nobody cares. My dad didn't care if his little sister ended up with $200 extra and 4 extra pieces of china. He did not care. And she didn't care what he got either.
But there's a huge percentage of people that do care.
When they do care, and when they decide that they're going to go to glory over some Hummels or some Beanie Babies, tangible personal property, it is oftentimes the most important issue in people's minds because there's symbols. The peacemaker is no longer around.
Right. One of my first mediations ever, professional mediations, was 3 sisters. And from reading the briefs, I couldn't tell what the dispute was. So I got them all in one room and I said, what are you all arguing about? What's the problem? And there was all this general discussion. And then when I narrowed it down, it's that one of the sisters wanted the cradle that the grandmothers had kept their babies in because she was pregnant. And the two sisters said, oh, well, that's fine. You can have the cradle. And it was done. We were done.
Yep.
So it literally got to the point of mediation.
Yes. Before anyone understood what they were arguing about.
Well, now, why would that be?
Well, sometimes lawyers see, okay, when I am first meeting with a client, I say, okay.
Yeah, let's back up to how we get to Judy. How do we get to Judy?
So a client comes to see me. Look, people don't see me unless they're having a real bad day. All I do anymore is litigation. We've talked about that. And when I meet with a client, I ask them, what do you want? What is your priority? Well, I want to see mom's wishes. And I want this. I want this. No. What do you want? Because a court is a one-trick pony. It takes money from A and gives it to B. That's it. The court cannot say, you did a good job or your uncle did a bad job. St. Peter himself could come down and pass judgment on this person, and they would never admit that they were in the wrong. That's not how people work. That's not how courts work. Courts are a resolution tool, and they're not a very flexible one, which is we go to mediators. And I do kind of a similar sort of thing when I mediate a case. I don't mediate very often, but more as doing MSCs.
Oh, okay.
So there are mandatory settlement conferences. A judge, there's...
Don't sidetrack.
No, but it takes a long time to get to trial. So a judge will say, go to this mandatory settlement conference. I'm making you go. And there are lawyers in the community. We volunteer.
So would that be like an arbitration?
No, it's like a mediation, but it's more compressed.
Okay.
And it's free. We volunteer our time, and sometimes they settle. But I'll start and say, okay, what would a good outcome be for you? Not the perfect one. What would a good outcome be? And if one side says, okay, well, I want money, and another person says, well, I want the house. Okay, now I have to facilitate this. But when I'm meeting with just my client, I don't know what the other side wants. So I say, okay, client, what do you want? Well, I want a solid gold toilet. I'm like, well, that's not going to happen.
Trump has one.
He does?
And the $5 million, whatever.
Yeah.
Gold card.
You're right. Oh, yeah. I forgot about them. But it's the, people in hell want ice water. That's not what we're here to do. What do we have to work with? And how do we get from where we are to your goals? And you have to prioritize your goals because you're not going to get all of them. And so what's really important to you, client? A lot of lawyers were not well trained in talking to clients. They're good at talking to judges and other lawyers. But, because this would be a really easy job if we didn't have clients. Clients are difficult. They are temperamental. They are going through a very serious part of their time. They're paying a lot of money for this, and they're usually not thrilled about that aspect. And they often don't know exactly what they want. So a big part of counseling a client is pinpointing what do they want, and then building a strategy of how do we get there. And so when preparing a client for mediation, it's, okay, we're going to find out what they want, because in mediation, offers go back and forth through the mediator. And there's the first offer, which means nothing.
Right.
And then
first offer is outrageous.
Oh yeah, it's how about we go back? We go out in the backyard and I kick you in the kidneys a couple times.
Going back to the brother sister, that was your first.
That was my first mediation
with Judy,
with anybody.
Oh,
but yeah, with my first with Judy. Actually, no, I had done one prior to that. But it was my first mediation with Judy. First mediation as a solo attorney, and
did I settle the case?
You settled the case.
Good. All
settled
right.
the case nicely. It went well.
Good.
And you invited me to be at your table at Probate prom that October. So I apparently did a decent job preparing my client. These offers go back and forth, and a lot of people who haven't been trained in deal making, they're trained to fight. I'm gonna write the best motion ever. Great, good for you. How does that solve the case?
And I would point out that when they file these papers, the other side usually sees them. And when they write in their papers, my sister or brother or whoever is a liar and a thief and is responsible for the death of our mother and is evil.
If I had a nickel.
Yeah. And the other side reads that and it makes it so much harder to calm everybody down.
I don't know why you would ever put that in a brief.
I see it all the time.
Yeah, and it's
I see it all the time.
I do. It's when I submit a brief for mediation, virtually always I share my brief with the other side. And if I have to say that the other side's a boogerhead or they have mental health issues, and it may be a legitimate issue, it's, hey, I want to let the mediator know you're going to have trouble working with this person.
Yeah.
And here's why. I put that in a confidential supplement. I don't flag that past the other person. I don't want to. Why would I do something that's going to make my job harder?
So, Judy, do you see a common, is there like a bell curve theme to most of the cases you work on where the majority are stepchildren, the blended family, or the caregiver took my dad and married my father and she was 40 years? I mean, is there a theme that you...
The most common is siblings. The next most common is step-parents. A stepmother and the stepkids.
The evil stepmother.
Yeah, the evil stepmother who's only been married to their father for 42 years and therefore isn't entitled to anything.
It was all a scam.
Yeah. The people take outrageous positions. And the most common source of disputes is mismanagement of the estate.
After mom and dad had passed away.
Yes.
Or even while they're still alive, but while they're declining.
Okay.
And no, mom wouldn't have ever given you that car. You have to give me half the value of that Toyota Celica.
Here's $20.
Yeah, right? And no, I won't. Mom gave me that. She wanted me to have that. Oh, God.
Yeah, when the clients come in and say, I just want what my mother wanted, what they're saying is, I know what she wanted. Nobody else did. And so we're going to have to settle this case in accordance with my intentions. And that's not going to happen. So I have to spend a lot of time disabusing them of that belief.
Oh, my gosh.
And there is kind of a dark underbelly of trust and estates law. We're taught, one of the few things we're taught in common knowledge about the will is that, the will is sacrosanct. What is in black and white in the document controls. Well,
not exactly.
If everybody agrees to depart from that document, hey, mom was mad at you because you didn't attend her second wedding to her third ex-husband or whatever. And so she cut you out. I'm inheriting this money. Sibling, here's the house you grew up in. I don't need it. I'm getting enough out of this. There's nothing to prevent that in most cases. Now, you lock up money in trust for generation after generation, which that never blows up and sinks. I've had a number of those cases where, things have been held in trust for just ages and there's accusations of mismanagement and so on. When you get everyone together, and Judy's done this more than once for me, where she hammers out a deal which probably isn't quite what the deceased parents wanted. If they had a magic wand.
I don't care what the deceased parents wanted.
And why not?
They're dead.
They're dead.
They're dead.
And I think as a parent myself, what they would want more than anything is for their kids to not fight with each other.
And certainly not spend all their inheritance on lawyers.
That's right. And me. So far better to resolve it.
So give us the idea of time is involved with a mediation. I mean, is it a day's worth of conversation?
Some attorneys have a good idea of how long it will take, and they'll either schedule half a day with me or a full day with me. And some mediators will take their cases to midnight, 1 a.m, starting at 9 in the morning. They'll go past midnight. I won't. I'm too old. I can't do it. So I'll stop at 6. And if it isn't resolved, then we just pick it up the next day or another day that we can do it.
Do people come to you prior to the poop hitting the fan and going, Does that ever happen?
Yes, before lawsuits filed?
Yeah.
Absolutely, quite a bit. And I
Okay,
encourage it. I think it's great.
Oh, yeah. I tell clients a lot of times when there's a fairly discrete situation, where you need to file a lawsuit is when you need to make the other person answer, or you need to use discovery to compel them to provide you information, or you need to file subpoenas, something like that. You need a case number for that. Generally speaking, if, hey, I've got the medical records, I've got the financial records, I'll give them to you because you're going to get them anyway. Let's all save some money and solve this case without having to deal with it. I just had one with Tim Riley, one of our partners, probably 7 months ago, where that was exactly the case, where we agreed to extend the time period to contest the trust, and engaged in some back and forth, and kind of, you always want to soften up the other side a little bit before you go to a mediation, because if people think that they're going to get through a dispute without getting bruised, they will not make a reasonable deal. If both sides have traded a few punches, they realize maybe we should stop punching each other, because it's not fun to get punched. Like there has to be an incentive to settle. And so, yeah, we went back and forth, wrote some nasty letters back and forth, agreed on a mediator, briefed the issue, and spent a day arguing back and forth, and ended up resolving the case and got it.
One of my favorite types of cases to mediate before anything's been filed are elder law cases.
Okay, talk about that. That's a great topic.
One parent is living, for example, and the siblings can't agree on how mom should be or dad should be cared for. Should she be at home? Should she be moved to a facility? If to a facility, what facility, under what circumstances? How are you going to pay for it? If she stays at home, is she staying with one of the kids? And does that prevent the other kids from being able to visit because they hate the one that mom is staying with? Do we need to get professional caregivers in and case managers? And so you pull in all these resources that I've been aware of for 40 years now to make a situation that'll work.
So again, a lawsuit hasn't been filed. No. But everybody's lawyered up.
Not always.
Not necessarily.
Not necessarily?
No, I'll mediate without the attorney. In fact, I'll mediate.
So how would a case like that come to you? Who would initiate that? One of the
attorney
children
involved who knows to initiate it, or one of the parties knows to initiate it, or even worse, one of the parties is an attorney and initiates it.
Okay.
And they initiate it by calling West Coast Resolution Group and asking to schedule a mediation.
I didn't know. That's news to me, because in my space, I see my most common thread of getting referrals to what I do for a living is the caregiver and the children hate the caregiver, or the caregiver's the son or the daughter, and soaking every dime out of mom's and money, and I'm going to lose my inheritance. All that story, which
goes on and on and on.
Goes on and on and on.
Yeah, and I like resolving those. I like making a family copacetic again, settle down, calm down. You all love your mom. Let's just take care of her.
Do you think they're celebrating Thanksgiving together after your...
I've had a few that hugged it out in the hallway when we were done, and that just warms my heart. I mean, that is such a...
You have a heart?
Yeah, I do. It's a secret, but I do.
Okay. Hear that, JoJo?
Oh, yeah, so I like that.
What about conservatorship? Do you handle that as well through mediation?
Oh, yes, absolutely.
And how would that work? How do you settle?
You might come to mediation because two people have filed to be appointed conservator of one person. So they come to mediation to try to work out who will be appointed rather than having a trial about it. Or there might be one of them's a conservator and has filed an accounting with the court as to how they handled the money, and a family member objects to it. So they bring that to me to mediate the resolution of the problems with the accounting. sale of the family home.
That's a big one.
That's always a biggie. So all of those disputes can come to me.
Yeah, I love it when they want to split the family. Split it. I go, we can't really split the real estate.
doesn't work.
Doesn't really work that way. Yeah. So in your space, again, you're getting involved. You're not doing the planning side of it.
Not anymore. I will again at some point in my career, but no, I like planning. It's a little repetitive for me. What I really enjoyed was getting to know people, getting to meet with all these different clients and understanding, okay, this is the level of complexity that they want and can handle. Because all kinds of people want to come in with these complex trusts with committees and things. They just don't work. A lot of times,
they don't work.
Sometimes if you have a really sophisticated, business-minded family that dot I's and crosses T's, it could work. It tends not to, and it tends to run into a lot of issues, particularly with incapacity issues. The Donald Sterling case with the Clippers a few years ago, where he was he incapacitated, and did his wife have the power to sell the team and all that? That was based off of two little lines in the trust. And Donald Sterling, he had some walking around money, and his plan was very tax efficient, I'm sure, but did not intentionally prepare for that scenario. So it's figuring out what do these people need, and what level of complexity will they pay attention to? Will they come back to me every 5 years? If not, well, then maybe we should leave things a little more open. And, you explain this to the client. And as with all things, for me, it comes back to beer. You can have great taste, or you can have less filling. You can't have both. And
I like your directness.
I learned a long time ago that beating around the bush got nowhere slowly.
I'd have to be invited to one of your mediations where you're two together. Because Joe, we know your language can,
a little salty on occasion.
And actually, so I never got to the second point from that first mediation.
Oh, okay. I'm sorry. Yeah, go
I
ahead.
had this guy. His mother had been very controlling in his life, and I had told him ahead of time, the mediator is not your friend. The mediator, from an economic viewpoint,
Understood.
The mediator wins if the case settles. The mediator does not make any more money or any less money if one person gets a better deal than the other. And if a mediator identifies one side as being more flexible than the other, you're going to get to be flexible. Now, you don't exploit it, but if this person, they're just not going to settle for that. Are you willing to come up or go down? That's going to happen. So telling him, look, don't just spill your guts to her. And he did it once, and I stopped him. And he starts running his mouth again. And I looked at him and I said, Bill, shut up. I need a moment with my client. And
I think you do.
Yeah. And she laughed and left the room and understood what was going on. And he wasn't even mad at me. He was like, yeah, I was doing it again. And so it's, you got to talk to people like they're grown-ups. You meet them where they are. And, like when you have a non-represented person and they start talking like they're a 19th century Pope.
Yeah.
And,
a 19th century Pope?
Very formal, very well. When I went to conversate with that particular individual, we came to this conclusory argument. And it's just like, what? Just talk. You do it every day. Don't, and it's weird because in law, we're like one notch away from Harry Potter. I go to a special building where there's somebody in a robe sitting on an elevated chair. Some lawyers go up, we say some words, some of them are in Latin, and all of a sudden one side owes the other money. I understand why it looks like witchcraft.
Oh, good point.
But it really isn't. It's just there's these complex rules that are applied by people who are very fallible, some of them more than others. And so you got a disagreement. How do we solve that disagreement? And what is it? 97% of cases resolve without a trial?
Yes.
97, 98.
And trial is very expensive, much more than your fee to mediate.
A 1-day fee to me is nothing compared.
So again, for those that are listening or thinking about moving in a direction where I am going to go after every penny that my brother is, whatever it is, really rethink your motive.
Well, and I will sometimes say to a party, it's going to cost you $50,000 to go to trial.
Minimum.
You need to raise your numbers.
Why don't you? I know.
It's 75 now.
I don't know how the common person does it.
Most of them don't.
If it's going to cost you $75,000 to go to trial, give it to your sister instead of giving it to Uzi.
Yeah. And I'll look at my client and I'll say, yeah, that makes sense. Do not spend money on me for a maybe when you can buy peace today.
So, Judy, I want to go kind of circle back. And again, we've talked about a lot of the aftermath of disputes and what happens with going to litigation, mediation. I really want the audience to understand Professional Fiduciaries Association of California, the professional fiduciary world. Do not name you made a comment, do not name your children.
Yes.
Talk about that. Now, we are in California. It's a licensed situation here in California. Yes. Hopefully it can go around the country a little bit more in the sense of actually having a license, some kind of more.
Well, and some other, Florida, for example, has a very well-developed certification process, but I don't know if they have licensure.
It's called guardianship in many places, and we call it, fiduciary. Tell the audience, what is a professional fiduciary in California?
It's a person whose occupation is to manage other people's estates and sometimes to manage their personal care. So they might act as a trustee for a family. They might act as a conservator. They might act as an executor or administrator. Sometimes they're named in powers of attorney to act because their interest is in doing it correctly. And they know how to do it correctly. The kids don't know how to do it. They're not trained in being a trustee. They don't send out the required notices, so the time limits don't start running, and they don't give the other siblings, they especially exercise control over their siblings, like, ha, 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 I'm in charge now, so you can just bite me.
I am the captain now.
Because I'm going to do whatever I want, however I want. And a professional fiduciary would never do that.
I've known a few who've tried.
Nah.
It's there. Look, as with any other profession, there are cases that are not handled as well as some others. Now, generally speaking, I have been a big honk for professional fiduciaries for a long time.
Big honk?
Yeah, a promoter.
Okay.
I wasn't sure what that meant.
I honked my horn for it. Okay. So I talk weird. All right.
I have a trust, one child, and I still have a private fiduciary named in my trust.
Good for you.
Because I don't think my kid can handle my estate.
Well, and I don't want
the
my
job
kid to. I mean, I did some fiduciary work when I first got my license because I had a powerful need to eat. And there just wasn't a lot of work in 2011, 2012.
Yeah.
And it's tedious. You have to go to the bank. You have to sit and fill out the paperwork and think about what you do for your own life every month. You can put stuff on auto pay. If you have a couple extra subscriptions to Audible or whatever, no one cares. But when you're doing it with someone else's money, you have to be perfect. And it is not something it's not something most people find rewarding. It is not something that most people are naturally inclined to do. The people who do this work, and particularly the new crop that's coming in finally, is that they are fastidious and they understand the need for this to go well and to be work properly. And that's all they do. They don't then go and then run a business. They don't go, well, some of them run their own business, but they don't go and practice law. They don't go and then work as a doctor or a pharmacist or a mechanic. We have our lives. So you're going to manage your life and somebody else's? That's a big demand. And it's not one that I'm in a big hurry to do.
And one of the real difficulties they have is they're administering a trust to protect somebody, and that person doesn't want to be protected. They don't want their money restrained. They want to blow their money on alcohol or drugs or whatever it is
Gambling.
they might want to do.
Hookers and fire trucks, whatever, something fun.
And the trustee has to say no. And, all hell breaks loose because of it. It's a very demanding, difficult, complicated job.
Mm-hmm.
Well, Judy, Uzzell, and I thank you so much. Special guest. We driving up here to come up from Mission Hills is a long schlep, but we so appreciate you doing that. You are truly, for those who are in San Diego, you are probably one of the most well-known, recognized names in the industry, and you took the time out to join us. So we do thank you for that so much. And it's just been a pleasure to have you today.
It's been my pleasure, Ron. Thank you.
Thank you.
You say that when the cameras are on.
Yeah. Turn the camera off.
Last words to Judy from you.
Oh,
you adore me.
I do. It is. I've learned a lot from you and how you mediate cases, and it's made me a better lawyer for it.
Good.
Well, yeah. It's when you're out and chatting by the coffee pot because your client's being a little difficult, and say, "Hey, look, here's where I think we can get it to go. I don't have this authority yet. How do we get there?" Your candor has always made my job easier.
Good. Glad to hear it.
So in the back of your mind is what would Judy say type of?
Well, that's always entertaining. But it's just, when people mean what they say, it makes my job a lot easier. And Judy says what she means.
The prime example of that was I clear names before I do the mediation, make sure there's no conflicts of interest. Well, I had a mediation come in, and I walked into the room for the first time, and I saw, were you in that?
No, but you told me, but I was in a mediation like the next week.
There's a party sitting there, and I look at him, and I know him from the dog park. I had no idea what his name was, and I can't stand him. And I looked at him, and I said, I know you and I don't like you. And he said, well, I don't like you either. And I said, yeah, I know. She said, but will you mediate the case anyway? And I said, no, because you won't believe anything I say. He's really a bit of a, really a bit of a problematic person.
You think?
Yeah. I cleaned my language up.
Yeah. Well, no, this is like this. Yeah, we don't have. We're not FCC. We're not FCC regulated. So I don't know if you want more business, but if you want to give out your website, because West Coast Resolution.
That's how you find me. Is
West Coast Resolution Group. If you really want to see a top tier group of people, go to the who's who.
We have the largest probate panel of any mediation, and what I like about our service is we're a nonprofit. So all the profit of our work goes to the National Conflict Resolution Center, and we're the only nonprofit mediation. So I like the fact that the money's being used for good.
Wow. We'll end it there.